I'm going to tell you what to do if your speeding ticket arrives late. We're talking about a situation here where a vehicle has been seen by an automatic speed detection camera. The police then have to serve a notice of intended prosecution on the keeper of the vehicle within 14 days of the offence taking place. If the notice isn't served on the keeper of the vehicle within that time period, then the driver can never be prosecuted for the speeding offence. Now, the first thing to say is that the police normally send a combined notice of intended prosecution and requirement to provide driver details on the same document. So even if you receive the notice late, you must still reply to the requirement to provide driver details part of it. If you don't, then you could be prosecuted for failing to provide driver information. That will get you 6 points, even if you were never done for the speeding, and the 14-day rule does not apply to that part of the notice. So you always have to reply to the notice. Now, let's say you've replied to the notice, but you're still sure that the original notice was served late. You can then defend the speeding charge if it goes to court. So if the case were to go to court, then the defence will be that the notice of intended prosecution was not served within 14 days, and that will be an absolute defence to speeding. But you should beware of this situation. There are all kinds of pitfalls that you might fall into, and I would suggest that you take some legal advice before you take a case to court. The reason I say that is that in lots of speeding cases, you might be offered a driver awareness course, or you might be offered a fixed penalty, which is much easier and much cheaper than court proceedings. So you only really want to take the case to court if you are going to win. Now, as I said before, if the notice was genuinely served late by the police, then the driver could plead not guilty to speeding and take the case to trial. But there could be all sorts of reasons why the notice didn't arrive with you within the 14-day period. And if any of those reasons apply, then you do not have the defence and you will lose the case at court. Now, there could be all sorts of reasons, but I'll just go through the most common ones. The first most common reason is that you're not the registered keeper of the vehicle. So the original notice of intended prosecution only has to go out to the registered keeper. So, for example, if you're driving a company car, then the leasing company or the company itself might be the registered keeper. Only they have to receive the notice within 14 days, and then anybody else who they nominate can receive the notice later. There's no time limit for them. Same thing applies if it's your car, but it's actually leased. The notice goes out to the leasing company, and you're not going to get the NIP within 14 days, so the rule doesn't apply. Another exception might be if the police have looked on the DVLA database and there's some kind of problem with the database, and the police have done nothing wrong, and for that reason they have to serve the notice on the registered keeper late. In that scenario, you wouldn't have a defence, and the notice would be perfectly valid. The third most common reason is when it's the fault of the registered keeper that they didn't receive the notice within 14 days. Now, this is the situation where maybe you've moved house and you haven't updated the V5C with DVLA, and so the DVLA don't know where the registered keeper of the vehicle lives, or they know, but they've got an old address. That's very different from updating your driving licence. So if you update your driving licence, that doesn't update the vehicle details. So say, for example, you've moved and the address isn't up to date. The requirement is to serve the notice on the address that's been given to the police by DVLA, on the registered address. As long as that's done within 14 days, then the police comply with the rule. So I'll say it again, that the warning is valid. Don't go not accepting a course or a fixed penalty and taking the case to court because you think that the notice is out of time. It's in fact quite rare for notices to be served out of time. So I would always suggest that you get some legal advice before you go down that route, because it could cost you a lot of money.